So I would request all the participants to join in for the first panel discussion, which is starting just now. So the topic for the first panel discussion is IP enforcement strategy, how to demonstrate value to the business. We have our eminent speakers joining up for the session: Scott Schneider, IBM Worldwide Patent Engineering Lead from IBM Research. We have Sheetal Talwar, she's a Deputy General Counsel with Tata Chemicals Limited. We have Dr. Murthy, he's a head IPR department from Neuland Laboratories. Mishra, head legal and company secretary from Tata Consulting Engineers Limited. We have Chike Ekwueme, who's managing partner with Ekwueme, Barristers and Solicitors. We have Scott Seeley, co-founder, registered patent attorney from Eastgate IP, and the moderator for the session, Mohan, senior attorney and leader, global innovation, intellectual property strategy, Dun & Bradstreet. So over to you, Smrithi.
Thank you very much. Hi, everyone. I am happy to moderate this presentation today. I hope everyone has been staying safe and healthy during this pandemic. I will kick off the presentation by first sharing some key points on how to build an IP enforcement strategy that really reflects and supports your brand. My perspectives are predominantly from a US perspective with some elements that apply globally. I look at building an IP enforcement strategy as a 5-step process. First, take an inventory of all of the IP you have, which can include patents, trademarks, domain names and URLs, maybe copyrights as well. If you do not yet have any, look at what you might have that is protectable and work on seeking protection. Next, understand your obligations to enforce certain IP rights. You need to understand which rights are owned by you and what you need to do to preserve and grow those rights. Third, understand what your deal breakers are. What are the things you absolutely cannot tolerate? For example, most would agree that a third party's use of your brand's trademarks without formal licensing of use of those trademarks to the third party would be a deal breaker. Fourth, determine your available budget for implementing enforcement strategies. Sometimes budget can be restrictive, but it's possible to enforce inexpensive strategies, and I'll discuss that. And fifth, create guidelines for identifying infringing forms of use and determine an action plan. What many organizations sometimes do not understand is how important it is to protect your innovation and intellectual property to begin with. This itself is a crucial enforcement strategy. I've spoken to people who tell me they either simply do not have the time to work on a patent application or cannot afford to protect their IPs, so they don't seek that protection. On the flip side, it can be even costlier to an organization if that protection is not sought after. For example, by not spending the initial monetary amount needed to file for a patent, you allow your competitors to offer similar products, file for a patent covering similar innovations, since in patent law, it doesn't matter if you were the first to come up with an idea, it really only matters if you were the first to file. Which can then result in pricing and sales erosion due to competition. It can diminish the value of an asset that you may have hoped to sell or to license. It can cause you to forego exclusive rights in your technology investments. And it can even result in an injunction to stay out of the market and court-ordered damages assessed against you. So think about how much more detrimental that is for your company as opposed to spending the money to file for a patent application on your innovation. It not only ensures that your innovation will not be copied or stolen, but it also establishes your authority and your standing in the market against competitors. And it also establishes an incentive. So whatever you create can proliferate and benefit more people without violating rights. So again, register your copyrights, trademarks, and patents as a basic enforcement strategy. At my company, we look at every patent that we're filing and determine where it needs to be filed, not just based on where our technology will be sold and distributed, but also in countries where there is a market for it and a risk of someone else potentially filing for a patent before we do for similar technology. This is a defensive enforcement strategy we use to enforce our patent rights all over the world and help legally enforce our standing as experts and leaders in the market globally against our competitors. Second, register your business, product, or domain names. These names are part of your brand. Even in cases of sole proprietorship where you conduct your business under your own name, it will help secure registration. You also gain legal protection that makes your business and IP a separate entity from you, which will prove valuable should you run into legal court issues. Domain name registration can also be an excellent strategy. As part of my own company's enforcement strategy, sometimes we need to register domain names that we may not have a plan to use at the moment, but they incorporate our company's names or most frequently used trademarks. So by registering for those domain names, it helps to prevent brand dilution and the risk of a third party registering that domain name and misrepresenting to our audience that they are part of our company. Third, I recommend creating confidentiality, non-disclosure, or licensing contracts for employees and partners. This can be a great enforcement strategy and also inexpensive to ensure that proprietary details of your innovation do not come out in the public prior to filing for IP protection and prior to a public launch of your product or service. Licensing contracts can be great for granting a third-party partner access to products or technology or even trademarks for their use, branding, and their distribution. For example, companies like Disney do this to allow toy makers and distributors to create and sell Disney-related merchandise with defined parameters around the quality of the toys and the products and the distribution process, as well as the use of any aspects of their IP. Once you protect your IP and your assets, strategies to enforce your IP rights upon infringement typically would include drafting and issuing a cease and desist letter to the infringing party as a first step. The letter would ask your infringer to stop the unauthorized or illegal use of your IP and to refrain from ever using it again in the future. It would also likely contain details of your ownership in the IP, referencing any relevant patents or trademarks, as well as a specific deadline by which the infringer must stop using the IP before you take further action. My team and I typically, we will try to include in our cease and desist letters any and all examples we can find of infringement, complete with screenshots of infringing websites and materials if relevant. The goal of the cease and desist letter would be to end the infringement promptly and avoid costly litigation. So taking the right tone and approach in the letter is extremely important to successfully address and resolve the matter. Depending on the situation, sometimes a strongly worded and aggressive demand letter is essential to grabbing the infringer's attention immediately and instilling some fear in them as to the consequences, whereas other times a more cordial and calm request is required for proper cooperation. Unfortunately, if your cease and desist letter is unsuccessful, it may require that you file for a civil lawsuit and perhaps even seek an injunction, which is a court order requiring the infringer to immediately stop their unauthorized conduct because your business would otherwise be irreparably damaged. So by not enforcing your IP adequately, you can run the risk of losing your IP rights. So it is very important to think about enforcement strategies with respect to initial protection of your IP and assets, as well as enforcement strategies against infringement once protection is obtained. So Scott Schneider, I just spoke a little bit about the importance of patenting and protecting innovation at large. So it would be great if you could discuss from your perspective at IBM a little bit about how IBM demonstrates the value of a patent license to a potential licensee.
Okay, great. Thanks, Smrithi. So once again, my name's Scott Schneider, patent engineering lead worldwide at IBM. I used to work with many US companies doing the same type of job. And the last, 5 to 7 years, I'm dealing with APAC and EMEA companies. So basically all companies outside the US or North America. So I have a pretty broad perspective of different companies and how they react to different things. So it's a little, I guess my perspective is a little bit different than Smrithi's. So most of the time at IBM, we're trying to license our patents rather than prevent someone from practicing the method, because a lot of times we might not be competing with them in that space, or even if we are competing with them, IBM, we kind of support more of an open approach, I guess. We're not trying to block people out from our inventions, but we do have another motive is why we're doing this, and that's because we're trying to bring money into IBM to support our innovation. So the reason we have such a large licensing program is because we bring the money in, and that further fuels our patenting. So it also fuels some of our research as well. So IBM spends, I don't know, 5 to 6 billion a year in research and development, and the IP income that we bring in through these licensings and other monetization efforts, such as selling patents, that all goes into invest in more patenting. But so how do we get people to license with IBM? So first of all, what is value? So in a patent license, at IBM's perspective and perspective that we tell our prospective licensees is freedom of action for both companies. So it's usually we're trying to establish a cross license. So the most important reason that IBM is doing this is for freedom of action. The second most important, I think, is what I described already, to further fuel our innovation. The other value we say is, you can avoid dealing with multiple companies. So license with us. We have about 65,000 patents at any one point. License with us because we have a lot of sales activities every year, selling thousands of patents to other companies. So if you license the patents with us, that license will transfer even if we sell the patents. So you can just deal with us and not deal with others. Another value is, settle with us for a lower cost up front here and avoid litigation. If you have to go to litigation, it's much more costly. I don't know, 5 to 10 times more probably for the value of the license. And the other value that we try to push forth is a partnership. We're not here for just one transaction and go away. I read somewhere someone was talking where it's not like buying a car where you go in and you buy a car. You don't really care if you anger the person because you probably won't see them again. So we have to really maintain a healthy relationship because we're probably going to deal with this company again. So we start with a really friendly approach, and we try to keep that friendly approach. Many companies we deal with are IBM customers, and we really value their business with us. So it's a fine line we have to walk because they're buying products and services from our company, but at the same time, we don't want them to use our intellectual property without proper licensing. So we have to balance that. So a lot of times, most of the time, 100% of the time, the company doesn't know they're infringing our patents. They have no idea. Almost all companies say, "Oh, we did a freedom of action search, but we didn't find we were infringing your patents." And so most of the companies are seemingly innocent and not, innocent to that effect. So that's the value we're trying to demonstrate. How do we demonstrate the value? We pretty much show, we do a lot of comparative analysis between our portfolio and the prospect's portfolio, if they have a portfolio. So if they have a portfolio, it's usually smaller than ours. It makes the job a little bit easier. We try to show quality, quantity metrics. We try to figure out where they're patenting and say, hey, in the areas where you're patenting, you're doing a good job, but we're doing a better job than you in quantity, quality. We try to show that their patents reference our patents more than our patents reference their patents, to show they're more dependent on our technology, our intellectual property. We sometimes show another portfolio imbalance with rejections analysis. So we show that when they're trying to get a patent through the system, they're sometimes rejected by our patents in either the areas, and that also gives us clues as to what products or services might be infringing if you look at rejections analysis between patents. So that we go in, we show a high level. We don't really concentrate on specific patents. We're trying to establish a relationship where we'll do a cross license. There's usually a balancing payment that comes to IBM, and we can maintain that relationship. Have a recurring term license. Let's say every 3 to 5 years, we go back to them, we talk again, try to keep it very friendly. Sometimes they're not convinced, so we have to show them specific patents, as Smrithi talked about, some documentation. That's one of my main jobs, is researching companies and their products and developing claim charts and presenting them to the clients. So sometimes we have to go to the claim chart route where we have to show them specific patents. Nobody wants to go down that route because it takes cost on both sides. It actually raises the license price because we have to put more effort into it. We have to use more legal resources, engineering resources. So that's the general approach of how we demonstrate the value, and that's what the value would be to both companies involved. Um, and we're trying to avoid litigation, as most companies are. So we try really hard to have sort of a win-win situation. Try to say, by doing this, there's other things you get out of it. We know you have to spend some money to get a license, but there are some benefits that you can, convince your upper management of this process.
Thank you, Scott. I think that was really helpful. I really appreciate your perspective from trying to license your IP and further fueling innovation. Sheetal, you work for Tata Chemicals, an India-based company, which is into such varied businesses. So how do you manage addressing all those business needs, and how do you demonstrate the value of IP related to those different businesses?
So thank you so much, Smrithi, and thank you so much, Scott, for telling us about IBM. It was really nice. So we do something different. We do not license out that much. We may be licensing in a bit. But before I start speaking about what Tata Chemicals really does, I want to give you a background of what my company is all about. Yeah. So we're into 4 kinds of businesses. One is a basic chemistry business where we deal with products like soda ash, sodium bicarbonate, and salt. And these are products which are made in bulk. Then we have specialty chemicals, in which we mainly have performance materials, which is primarily silica. We have nutritional sciences, and in that we've developed a lot of food formulations, ingredients. Pharma, and we supply to the pharma industry. And the third thing in this is the agri-sciences. The agri-sciences is mainly handled by our subsidiary, which is Rallies India. Now, having said that, what we do is we try and build an intellectual capital where we have robust new product launches, we have product registrations, we try and enhance our intellectual capital in-house. So we have a lot of R&D centers. One of our main R&D centers is the Innovation Center, which is based in Pune. And I would be proud to say that we've got about 220 technical people already in the system. They create a lot of IP. So whilst we create value for the businesses within the company, we also do a lot of research where we can provide to others. So those are 2 kinds of things which normally happen. How does the business, coming to your second question, how does the business help? How does the business ask us for help, and how do we provide for help? So from the initiation of an idea, if the business wants to get into a product wherein they manufacture the product themselves, they will package it themselves, they will brand it themselves, the design of it, the patenting of it, everything is done by us. So what happens is, I'll give you an example. When we were planning to launch a water purifier, before it was launched, and the IP department was taken into confidence, because you would have heard of the product called Tata Swatch, which was a water purifier, which was Mr. Ratan Tata's baby, really. So what happened at that time is that we registered a trademark before the launch of the product. We had several designs in the product itself. We saw to it that before the product is launched, we look at all the IPR and we actually register all the designs. Apart from that, the main thing that we did is we conducted the freedom to operate, which was for India and for a few countries abroad. Now, whilst doing the freedom to operate, we knew that there were a few parties who had got patents on general ideas, not on specific ideas. So there was a period of time where these general ideas were patented for some reason or the other. I can't really put my finger onto it. But since they were patented, we were not allowed to go into that space. So what we did is that before we launched our product, we filed our pre-grant oppositions. We filed our post-grant oppositions, which means that if we were ever caught for infringement, or if we were ever sued for infringement, we already had something in place where we've already tried to invalidate the patents of the others who were already in the market or who have got generic patents. We obviously fought tooth and nail, but at the time of doing the FTO, at the time of actually launching the product, we tried to block and we tried to cover all the blind spots that may come after the launch of the product. It was very essential to do that because the product was small, right? When a product is launched, it's a small baby. So you're investing maybe a lot into the product, but the returns may not be that much on an immediate basis. So you don't want anybody coming after you. So having addressed all these blind spots, yes, we did come across a lot of pushback from the competitors. And they told us, okay, how have you got this? How have you managed this? Show us your patent. You know, they tried to give us some notices, this, that, and the other. But because we had done all our homework before we actually launched the product, be it the trademark, be it the copyright, be it the designs, be it filing of, we filed at least 14 patents. We had a full family of patents. We filed 14 patents on the various components and the processes that we were going to follow to have the water purifier actually running and successful. We had a lot of pushback, but today I can be proud to say that the water purifier is doing well into the market. We have everybody who came after us, and there were a few patents who actually got out of the registers because we filed post-grant oppositions for those invalid patents. So having said that, the strategy or the work that the IP department would do is primarily to address everything that could be a risk that we may envisage after the launch of the product. And God forbid if something does happen, well prepared and we can push back the people. The third point that I want to put across is that in all companies, licensing in and licensing out is very common. So when we need to license in from outside parties or when we need to get into collaborations with outside parties, we do that with a lot of universities within India and abroad. We see to it that they evaluate our work, our research work that they've done. They give us the results. We try them on the products that we wish to evaluate and use and put it into the business. And only then we go ahead. So this is a little bit about, what Tata Chemicals as a company does and what we assist in the business to go ahead and launch their products without a scare.
Thank you, Sheetal. That's really interesting, gives us excellent insight. I think the points you raised about blind spots and how to deal with the situation when patents in general spaces are already existing and you're avoiding an infringement accusation is very, very helpful. So thank you for that.
Thank you so much. Thank you.
Absolutely. Actually, I think that is a great segue to generally speaking about IP enforcement in India. So Dr. Murthy, would you be able to share with us some of the problems in enforcing patents in India?
Yes, hi to everyone. The thing is, in India, especially if you come to the pharmaceutical sector, especially scientists will be afraid about the enforcement of the patents, especially process-related patents. Because what happens, there is no linkage between the regulatory and patent. If there is a linkage between the regulatory and patents, then enforcement might be a little bit easier. But what happens mostly, especially in product patent enforcement is okay. We can enforce easily a little bit in India when compared to the process patents, especially in pharmaceutical process patents or chemical process patents. What happens? Generally, small companies will go there and copy some patent, and we don't know, they may supply to some non-regulatory market also. So enforcing of the process patent is becoming a little bit a challenging thing because there is no linkage between the regulatory approval and patent. In fact, because what happened for any pharmaceutical launch, what happens, the companies goes to the regulatory department and take the approval. But they don't give any information about the patent, what process they are following, and that kind of information is not required for the regulatory approval in India. So what happened, maybe so many companies, small companies are copying the same process and doing it lesser price, or maybe sell it to the some non-regulatory market or somewhere. So if you have a linkage between the regulatory affairs and a patent, that means while registering the product itself, if you have given the information about the pure patent at that time, and then only if you are able to register, then what happened? Enforcement of the patent will become very easy in India. Due to that reason, what is happening? Some of our scientists feel little bit tension to disclose everything. Some of the people says that, especially academic scientists, I can say, if you go for ISCT or some CCMB or whatever maybe, especially academic scientists used to tell that, okay, if you file a process patent or something, composition patent, someone may copy our process or composition, because there is a no linkage between the regulatory and patent and patents. So if you have some kind of regulatory linkage between the regulatory and patent, then enforcement will become a quite easy in India also. Of course, nowadays all companies are taking a non-infringement statement from all suppliers. That is already started, and so almost we are safe, I can say, because slowly we are also in a system of taking from all our suppliers non-infringement statements, and we are doing our best. But the thing is still, we can't say that some infringement may take place because due to not having this kind of linkage. So we suggest to have a this kind of linkage in India also.
Okay, thank you. That's helpful. I think you kind of answered a little bit of my my follow-up question, but I don't know if you have anything else to add regarding other suggestions you have to overcome some of these problems.
The thing is, what we suggest to our scientists is, sometimes in designing our process itself, we can have some kind of advantage. I can tell you a simple example of linezolide. Linezolide is one of the pharmaceutical API. What the scientist has did, they have a novel intermediate, and the final product, if anybody copy our product, if following our process in final API, you can find out the impurity. With that impurity, we can catch out that any person is copying my process. Because what happens, form 3 is a linezolide polymorph. So what happens if anybody copying our process by taking out our competitive product, and if you check that, in the impurity, if you find out this intermediate, because without this impurity, nobody can synthesize that product. So if you find out that impurity in the final product, means someone is following my process. So that kind of things we generally tell to our scientists, but it's not possible every time, because it is very difficult to do that kind of inventions, because cost plays a major role in invention of everything. Because what happens in the competitive market, what happens, mostly people target is cost only, rather than, I can say, invention. Because as I was taking care both IP and portfolio and strategy in our organization, sometimes when you want to launch any product, most important part is the cost. So in such a case, maybe small companies or some companies may copy it. So enforcement may be a little bit difficult, especially product patents. I can say that in India we can enforce very easily. There is no issue in enforcing the product patents, but little bit issue is there in the enforcing of the process patents. That's what from my side.
Thank you very much. That was good insight, especially product patents versus process patents. I think that's an issue that is apparent in many other parts of the world as well. So definitely good insight. Chike, since Dr. Murthy just described to us some of the problems in India, maybe you can talk to us a little bit about some of the issues in Nigeria and Africa at large. So, in your jurisdiction, what remedies are available to a business whose intellectual property rights have been infringed?
Thank you so much, Smrithi, and thanks to the rest of the panel for wonderful insights. I've been taking mental and actual physical notes of most of the contributions. In adding value to a business, like Smrithi said at the beginning, if a business is not willing to actually enforce their IPRs, then there's really little reason why you even create them or even seek to protect them by form of registration or other means. And so in enforcement, what you're really looking for is injunctive relief, which is a permanent restraint from a competitor from illegally using your trademark or copyright or other forms of IPR. What you're looking for, what is known as a perpetual injunction, because it usually comes at the end of the court action, you want to have some interim relief, or we call interlocutory injunctions. And there are several kinds. We have what is known as a Mareva injunction. It's a common law injunction that freezes the accounts of the offender even before they are made aware of the court action. You could also have an interlocutory injunction which restrains them from carrying on the infringing action until the court action is concluded. You could also have an unpopular order. Now, what you also need to appreciate is that in enforcing your rights, you have to be a little bit of a private eye. You have to do a lot of investigation and fact-finding. Where are these goods being sold? What platforms? Like today, most of it is going on online, because since COVID, for instance, depending on what statistics you're looking at, the growth of e-commerce within this region has been anything from 27% to 42% in 1 year. That's between 2020 and this year. And so a lot of infringement it's taking place online because obviously once you have a growth in e-commerce, counterfeiting is much easier to carry out. And so vigilance has to be exercised not only in the physical marketplace, but in the internet space. And this is a word to attorneys, both in-house and external counsel advising rights owners. You need to pay much more attention to the online space. So your investigation, your fact-finding has to take both approaches. And once you find that there's infringement, you should be able to find out more about this company. Where are their bank accounts located? And you can use law enforcement to assist you in these steps before you even file a court action. Because once they're notified of a court action, they might destroy the evidence, or they might hide it, and you can be able to locate it. An unpopular order allows you to seize assets even before and put them in court. So you don't seize them and take them to your warehouse. You take them to the court, and then the court action proceeds. And you would find, like I think it was Scott that spoke a lot about settlement. You would find that you could arrive at settlement much quicker if you take these preemptive steps before actually notifying the third party of the infringement or of the court action. Smrithi, you spoke about the cease and desist letter. That is useful where you think there's innocent infringement. But in this market, you actually have to take a more aggressive stance most of the time. Now, we have issued a very strongly worded cease and desist letter just last week. And the rights owner felt that, they felt that the trademark was not being infringed in bad faith. And so we had to tone down the language so that we could invite the other side for negotiation, possible ADR, and so on, rather than going to court, because as Scott Schneider said earlier on, litigation is costly in Nigeria, Africa, as well as in the US and other parts of the world. And again, court action can last for up to 3 years or more in this jurisdiction. And so you want to consider whether you want to go ahead with litigation. But if the infringement is wide scale, it's deliberate, it's in bad faith, then you want to probably take these preemptive steps that I've tried to describe, just to get the other side to the table, or indeed to close down their business, which might be the end result of what you're trying to do. Now, you also want to claim substantial damages. You could also ask for an account to know how much has been sold. This could go along with a claim for damages. Then there's also a class action where you're not sure of of one particular infringer, but you have an idea that there's a network of infringement going on, several importers bringing in the product or whatever it is, but you have one person you can lay your hand on. You want to sue that person as representing himself and all others who are importing, manufacturing, selling a product that resembles your the company's products. So those are the ways, the typical ways you can, the traditional ways you would go about adding value to a business by enforcing the IPRs of that business or company. Thank you so much, Smrithi. I'll be happy to yield the floor to someone else to take care of something. Maybe I can come back and talk about the courts, if that is okay.
Yeah, absolutely. Absolutely.
Okay, so
maybe I'll direct the conversation right now to Sachin, who I know deals with more project management type business, which is very common and very popular across the globe. So Sachin, why do you think should project-based and project management-based businesses conduct IPR plans and strategies as a key to their success?
Yeah. So good evening from India and good morning to you, Smrithi, and good afternoon to some of the panel speaker. Happy to connect you all and really very informative session going on so far. And I wish that all of you are healthy in this pandemic. So question what you asked about the what could be the strategic advantage of taking the IPR into consideration for a project-based business. So let me introduce you myself. I come from a company called Tata Consulting Engineers Limited. It is a engineering consulting business. So it's very unique to understand what is engineering consulting and what is engineering projects. So you must have seen the projects which are very huge, which are very large. You will find one of the biggest companies of the world doing those projects, whether in India, whether it's abroad, whether Jacobs are there, whether Ekwuemes are there, whether L&T is there. But behind these huge projects, there are very sharp and very effective brain which works towards the design and implementation of a project. So it's very important for a business to understand what I'm going to design, what I'm going to deliver. I'm talking about only the project. I'm not talking about the product. Okay. So when you have a project-based companies, you have to understand technology plays a role in determining what would be the who would be the winner and what would be the outcome of that entire project. So a project company or EPC company could be a company which delivers the project. How it delivers the project, it involves a better management, it involves better project planning, and of course at the end it involves project delivery. Then if you combine all this thing, how to make sure we are going not as per the plan, many times we are going much better than the plan. And to do that, when the project club with the technology, then only the outcome is achieved. Sorry. And what is the technology here we are talking about? So you must have seen in the project we have got different beam software, we have got drone technologies now. I'm sorry. We have got 3D cameras, we have got 3D tools, we have got digitization platforms, integrated tools, or there are various complex project management tools which are available in the market. What these tools and what this technology do, these tools and these technologies make sure that your project is not going outside the budget, which is very important. You will not believe, Smrithi, in India, we have just got a scheme, what is called Prime Minister Infra Development Scheme, and it's a 1 lakh crore Indian INR scheme. And you know what is one of the important factor of that scheme? How to make sure there is no project delay, because once a project is delayed, it has cost implication, it has got project implication. Cost implication could be maybe 20% or 25% of the cost. But the project implication, nobody knows. I mean, project is delayed. So once you have a proper strategy, which makes sure, which is using the technology, which are using the digital tools, which make sure this project is as per the plan and within the schedule. And if you have all this thing in the bucket, as Dr. Murthy had said, the process patenting is very difficult to do. But still, if you have these processes patented, let me tell you, you will get brownie point. You will get more money for the services. I can tell you, a few years back, BIM, the building, which was launched, it was never thought that this product will be so hit in the market. I mean, I still remember people when started taking the beam as a model. Nobody understood that the beam will be used across the globe so innovatively, and it's very happy to see that, because once the beam model, building information model came in, which was a clubbing of engineering brain with the software, it gives you information which is helpful for the business, sure that how the business will look like. So that's the use of IP or IPR in your strategy to develop the business.
Sachin. I do have a follow-up question for you, but before I ask it, I do want to give Scott Seeley a chance, because I know that I want to be mindful of time as well.
Sure,
So,
sure.
Scott, I want to come to you next, and I know you have your own practice and provide outside counsel services to so many groups and organizations. So. We've covered so many different aspects and issues and problems and remedies to dealing with IP enforcement across businesses and across the globe. So how can outside counsel provide value to the business when enforcing IP rights?
Yeah. So I think there's really a two-pronged approach that you can take to really demonstrate value to the business that you're serving when they're trying to assert their IP. So I think it first starts with doing your due diligence up front and building a strong foundation from which that you're going to assert that IP. And second, trying to find ways to preserve the resources of the business you're counseling. So as many people have said on this panel already, litigation is costly, expensive, and time consuming. And a lot of times it's best to try to avoid that if you can. So kind of to start with, for due diligence and how can you build a strong foundation, it's important to make sure that the business you're representing understands that any IP that you assert is going to be challenged. No business is just going to take infringement allegations lying down. So there's generally a few ways that they're going to do this. So at the district court, obviously that they're going to argue that they don't infringe your IP, but they're also going to attack the validity of your IP. They're going to assert that the patent's invalid and never should have been granted in the first place. But worse than this, there's a parallel proceeding that you can file before the patent office itself called inter partes review. And this is basically a mechanism where you're going to ask a board of patent examiners, administrative judges, essentially, to go back and review the work and ensure that the patent is valid and should have been granted in the first place. And the PTAB is actually a pretty dangerous place compared to the district court. So in a district court, you're entitled to a presumption that your patent is valid, and you don't get this presumption before the board. And there's also a lower burden of proof. So to invalidate a patent before the board, you just need to establish that it's invalid by a preponderance of the evidence. Whereas at a district court, they're going to be looking for clear and convincing evidence, which is a significantly higher standard. And there was a beacon of light in 2020 last year. We had a decision come out of the board. It was Apple versus Fintiv, and this set forth a few considerations that the board would take when determining whether or not to institute review. And one of those considerations was the existence of parallel litigation in the district court. So if your patent was already being litigated in court, you had a reasonable argument before the board to say that it's not worth the time to institute review, and you could kind of escape that way. But this year, there's been some holdings walking that back. Most importantly, Sotera, it provides a stipulation that a petitioner can make, basically preventing them from raising duplicative grounds in the district court. But this greatly reduces the chance of an early IPR dismissal. So it's really important for businesses to do that due diligence up front. And so you can provide a lot of value that way, helping ensure that you're going to be asserting this IP from a strong foundation. So the mechanisms that you can employ to try to vet this IP before you assert it would be to review the prosecution history of the assets, commission a prior art search that's perhaps more in depth than you did before you filed the application, and get some experts to review the subject matter because it's really important. So this kind of ties in with the second point of you need to preserve the resources of the business that you're representing. As many of my colleagues have mentioned, litigation is costly and expensive. It's very time consuming. On average, it takes about 2.5 years just to get to trial. Litigation costs start at around $1 million to $4 million just to get to trial, let alone complete trial. And then once you get the decision, there's still a lot of uncertainty because it's still subject to appeal at the federal circuit. So you really need to be sure of yourself before you go into litigation. There are alternative dispute resolution mechanisms. So arbitration and mediation is definitely one to consider. And arbitration can actually overcome a lot of these drawbacks. It's much faster than litigation. Most mediations are complete within a year. The costs are typically at least an order of magnitude less than litigation, but also they can be done privately. So unlike litigation, where it's going to be a public affair and most of those documents are going to become public record, you can actually complete an entire arbitration, mostly under an NDA or some other confidentiality agreement. So you can really keep the dispute out of the public eye. But perhaps most importantly, there's no right to appeal an arbitration decision. So usually there's only very narrow grounds that you can appeal, such as the arbitrator was corrupted or conflicted, but you can't just appeal because you're dissatisfied with the result. So if you're drafting your licenses to license IP to competitors or businesses, whatever it is, consider drafting the licenses with arbitration in mind, because that can give you an escape route to avoid litigation or IPRs altogether.
Thank you so much, Scott. I think it's an excellent point you make about mediation and arbitration as opposed to litigating. That's a huge, money is a huge consideration for so many people. So no, very, very helpful insights. I guess I'll go back to, well, I just got the notification. We have 5 more minutes. Maybe you know.
I had one more question, I know, but I also have a paper that I've put together about to be published. So if you want a more thorough analysis of enforcing IPRs in this region, do me a DM to my LinkedIn or an email, and I'll let you have the manuscript. You can look at it. I'm obviously not going to breach the copyright, so I'm sure it's in safe hands here. So I'll share that information about other bodies within Nigeria that help in enforcing IPRs, like the National Agency for Food and Drug Administration and Control, and the Customs, and the Police, and the Nigerian Copyright Commission, and their work in enforcing IPRs, as well as some of the other things I've said already, maybe a bit more insight into some of the other points I've made earlier. So thank you, Smrithi, for a wonderful moderation of this session.
Thank you so much. Thank you. I think maybe in our last few minutes, maybe we wrap it up by allowing each of the panelists to offer a key takeaway that they would like the audience to walk away with from this presentation. So Chike, why don't we start with you?
Yeah, my takeaway is the word vigilance. If you have IPRs in any jurisdiction, you want to be vigilant and ensure that you are watching. Once there's infringement, you act quickly. A lot of the remedies that I and others have spoken about have to do with injunctive remedies. And in our jurisdiction, they are regarded as equitable remedies. Now, in equity, there's a saying that equity aids the vigilant and not the indolent. And the other maxim is that delay defeats equity. So if you want to ask for someone's goods to be seized or bank accounts to be frozen, you have to act quickly. You can't know about it and then rest on your oars and expect the court to listen to you after maybe 2 or 3 months of knowing this. So vigilance is a key takeaway for me. Thank you.
Wonderful. Dr. Murthy? You're on mute.
Okay. I can say that a lot of change has taken in India from the last 15, 20 years, and a lot of IT-wise, India is improving a lot, I can say, and I can say we are filing a lot of patents, process patents, product patents, and everything. Of course, that linkage issue is there, and remaining way, little bit education, IP education is also required, even for academics, and that makes it better in coming days.
Thank you, Dr. Murthy. Sachin?
Take a word from Chike, not only vigilant, we have to be very careful with our IPs. Guys, we are on a global warming. And if you have an innovation which is not secure, which is not patented, if it loses the grip, it goes to somebody who is not a right person, he can misuse your IP. Being in corporate, which are very careful towards the society, from a Tata group, we can say that we are very careful towards the society, towards the employees. So at the same time, if I'm doing some innovation, I should be careful that innovation does not go to somebody's hand, which will be creating back to the society, or it contribute to the extra degree in the global warming. Very important.
Thank you, Sachin. Scott Schneider?
Yeah, I guess I would say if you're attempting to resolve like a patent issue through licensing those patents or the portfolio to a prospect company, and you want to avoid litigation and you're trying to go down a licensing route, keep it as friendly as possible, I would say, and try to make it a win-win situation. For example, let's say they still think they're not infringing, but they want to resolve the issue, so you stop bugging them. Perhaps you can, look at other parts of your business that you could build relationships with between them to help close the licensing deal, or perhaps maybe with the licensing transaction you could bundle some patents. Let's say they have a very small portfolio, you have a large one, let's say, maybe you can say, hey, license with us, we'll get freedom of action. And also, we'll also throw in, 10 patents of your choice in these areas to help build your portfolio. And that might help them sell the license proposal to their upper management. So those are some of and try to keep it, if you're trying to license, win-win is the way to go, I think, if you can get it.
Scott Seeley.
I think my main takeaway would be preparedness today pays dividends tomorrow. So if you're going to assert that IP, make sure you do your due diligence up front and make sure that you know that it's going to be strong and it's going to withstand the challenges that you're going to face. And find ways to stay out of litigation if you can. So draft those license agreements with arbitration clauses in mind, and really make sure that you give litigation a good thought before you decide to file.
Thank you very much. As for me, I want to emphasize that there's always a way to enforce your IP rights, even on the tightest of budgets. So, such as creating confidentiality and licensing agreements for your employees and partners, like I discussed earlier. Your IP is an asset of your business. If you don't take adequate or sufficient reasonable means to protect and enforce your IP, then you run the risk of losing your technology investments, assets, and IP rights. So every organization, from sole proprietorships to large corporations, can take even the smallest steps to enforce IP rights. So consider that 5-step process I discussed earlier and do what you can to protect and enforce your IP rights. Thank you.
Smrithi, I'd like to say my last few points on this one.
Absolutely.
Hello?
Oh, yes, Sheetal, sorry.
No worries. No worries. I was going to put it across in any case. So, the last takeaway I wanted to put across is that, address your blind spots before you actually get into the business. And I'd go with what Scott Seeley said, that, it's very, very important to see that you're not stepping on anyone's shoes and let nobody step on your shoes as well, because litigation is really expensive. Just keep evaluating your IP from time to time. Don't have white elephants in your closet. Chuck out what you don't need and retain what you need and license it out, license it in, and that's it. Yeah. Thank you.
Thank you, Sheetal.
Thanks, Smrithi, for moderating a wonderful session and keeping it together. And thanks to the key panelists and speakers who have joined us today.
Thanks.
Thank you,
Smrithi. Thank you, everyone.
Thank you, everyone.
So I will.